everyone, my name is Anisha and I am an intern at LEXIS and Company. Today in this video, I'll be discussing with you all the concept of writ jurisdiction of Supreme Courts and the High Court. To start with, I would like to say that what writ is. So, I would like to say that this writ, it is a remedy against the injustice, a device for the protection of the rights of the citizens, and it is also against any kind of encroachment by the governmental authority. Writs, they originally they came into existence in the Britain, and where they were king's prerogative writs, and they were the commands to the judicial tribunals or the other bodies to do or not to do something. Since these writs, they carried the authority of the Britain, of the crown, so they were to be obeyed, and it was necessary to obey these writs. Later on, these writs they came to be enjoyed by the judges of the King's Bench as well. And in India, this power to issue writ, it was vested in the Supreme Court and the High Court, and it is an extraordinary remedy that is exercised only in specific and special circumstances. To furthermore know about that, the Supreme Court, it has been empowered to issue writs in the nature of habeas corpus, mandamus, prohibition, certiorari, quo warranto, and for the purpose of protecting the fundamental rights, that is, and under the right to constitutional remedies. Similar power has also been conferred on the High Court via Article 226. The High Court can issue our writs, all the other writs that I just mentioned, for the purpose of protecting the fundamental as well as the statutory common law rights. The High Court can also issue writs to any governmental authority outside their territorial jurisdiction, provided the cause of action lies or arises in the whole or in part within their territorial jurisdiction. Now this writ, we can say it is a discretionary remedy, and the High Court can refuse it on the ground of acquiescence, delays, that is laches, and the available alternate remedy and no benefit to the party. And under Article 226 clause 3, a High Court can grant interim relief by way of interlocutory orders as well. While the jurisdiction of the High Court is more extensive than of the Supreme Court, Article 226 clause 4, it provides that it is the powers conferred on the High Court shall not be in derogation of the powers conferred on the Supreme Court by Article 32 clause 2. In one of the cases in L. Chandra Kumar versus Union of India, it was held that the person cannot go directly to the Supreme Court from the decision of a tribunal without first going to the High Courts, and thus the aggrieved person has got another remedy by way of writ petition before the High Court concerned, and thus what was earlier two-tier litigation has now become the three-tier litigation. The tribunals can ask the jurisdiction of the High Court under Article 226 and 227 as well, and the scope of the writs in Indian laws is wider than that of the prerogative writs in England. This is because, firstly, the Constitution uses the words writs in the nature of. That does not make the writs identical with those that were originated in the England, but only draws just an analogy from the latter. Secondly, the Article 32 clause 2, it does not require the Supreme Court to observe all the procedural technicalities that were relevant for the issuance of the writs under the English law. Therefore, even if the conditions for the issue of any of the writs are not fulfilled, then the court may still issue a writ in the appropriate case and if the situation such a specific situation arises, but except the cases of governmental policy. Thirdly, our High Court can issue directions, orders or the writs other than the prerogative writs. Then this enables the court to mold the reliefs to meet peculiar and the complicated requirements of the country. Like we know that how diverse this country is and how diverse kind of problems and aspirations result into creating the problems. And under Article 226, the writ can be issued to any person or the authority or any person or the body performing the public duty. So this was all about the writ jurisdiction of the High Court and the Supreme Court. I hope it was clear, and thank you for listening.